So, welcome to everybody on our Bristow's Legally Speaking Data Protection Update webinar. It's Robert Bond here with colleagues who I'm going to introduce in a moment. Bristow's, I think many of you know, we are headquartered in London and we are full service but with a particular expertise in data protection. And we're going to try and take you through some hot topics in the next hour. Again, many of you who are on the call know us, but broadly this is me. I am one of the partners in the commercial IP IT team and specifically focusing on data protection. And I'm joined today by Alex Dittel, also in the team. Alex has been in-house, was at Google and was on secondments at Amazon and Pfizer. And then Brian Johnston, another associate in the team who is dual qualified and again, like Alex and myself, works on a lot of large multi-jurisdictional privacy compliance projects. And finally, Emma Macalister Hall, another of the associates in the team, working on fascinatingly interesting projects, one of which we were doing earlier today. And the topics that we're going to cover on this webinar are how to make legitimate interests legitimate, particularly under GDPR, which I'm going to deal with. Alex is going to look at when is consent really consent under GDPR. Brian is then going to look at the Article 29 Data Protection Working Party guidance on data privacy impact assessments or data protection impact assessments. Alex is going to look at Malaysia data transfers, but briefly I think touch on some of the other Southeast Asia developments in terms of data protection. And then Emma's going to finish by looking at the Information Commissioner Office's consultation on profiling and automated decision making under GDPR. Remember that you can send in questions at any time using the question box. This will be recorded and, as I will mention at the end of the webinar, will be available for download from our website next week. So, how to make legitimate interests legitimate? This is an interesting opportunity for business. If we look at not just GDPR, but if we look at the current directive and its implementation in member states, there are several, or 6, means of lawfully processing personal data. We all know about consent. That's the thing we keep hearing about all the time, and to be fair, Alex is going to talk about it shortly. We can, of course, process personal data if there is a contractual necessity, and there are many occasions when in the online retail space your data will be processed as a matter of the delivery of Netflix or Amazon books or whatever. But then there will be other lawful reasons like legal obligation, like public tasks, but then we get right at the bottom to legitimate interests. There are some interesting examples which I will talk about that GDPR specifically calls out, where it seems to me that there is a great opportunity for business to look at legitimate interest as a way of doing things with individuals' data when either consent is not practical or it's disproportionate, and there may be some advantages to legitimate interest over other solutions. There isn't a hierarchy of grounds for lawful processing, so just because consent is the top doesn't mean it's number 1, any more than legitimate interest is at the bottom. Different legal grounds for processing carry different duties. So when we look at GDPR, and I'll talk about this again in a minute, consent in relation to personal data brings probably most of the legal obligations, gives individuals the right of understand profiling, right of erasure, right of portability, whereas those rights don't necessarily attach to some of the other lawful grounds, for example, legitimate interests. One thing that we still don't see, particularly in typical privacy policies, is a transparent statement of the grounds that are being relied upon or that might be relied upon by a controller. That is going to change under GDPR, and we are going to have to be more specific about what grounds we rely upon for lawful processing. So when we look at how to make legitimate interests legitimate, as I say, both the directive as well as GDPR flag this out, and I've put up there, and I don't propose to go through every word of the cut and paste from GDPR, but there is clearly the opportunity to use legitimate interests provided that the rights of the individual are not overridden by what the controller deems legitimate. And specifically there we see particularly where the individual is a child. It's interesting that Article 6(1)(f), it states in GDPR, doesn't apply to public authorities, but in some recent exchanges with the Information Commissioner, they are of the opinion that there may be certain processing activities by public authorities where legitimate interest is perfectly permissible. If we look at recital 47, which drives this, let's not forget that the legitimate interest may be as applicable to a controller as it may be to the third party who might also rely upon it. So if we take the wording there and move to the next slide, there are some key words that I want to just talk through. And I've just put at the bottom of this slide here the logo for the Data Protection Network, which I believe some of you on the call are already members of, but I wanted to acknowledge here work that is being done by DPN, where we are drafting guidance for controllers from cross-industry sectors to help assess whether an interest is legitimate and whether it can be relied upon for processing. So some of the points I'm going to go through in the next few slides are very much drawn from draft guidance, which we submitted just before Easter of this year to the ICO and also to the Irish Commissioner to seek their, I was going to say endorsement, but I know we won't get that, but to get their comments on what we believe is a highly useful guide for controllers in terms of carrying out what we will call an LIA, or a legitimate interests assessment form. And when we look at what GDPR is saying, there are basically a number of questions that the controller would need to ask itself. Is what we are doing with personal data strictly necessary? What are the purposes for which we are processing the data? Is it legitimate because we say it is, or do we have to recognize that the rights of the individual might override what we suggest is legitimate, what are the interests that drive us arriving at an assessment that it's legitimate, and what are we balancing our assessment against, or our decision against. So we end up, as a controller, looking at a processing requirement and saying, do we actually need personal data to carry out this particular activity? If we do, is consent the right solution, or is there a different solution? And if we feel that legitimate interest trumps everything else, what is the ground for arriving at that decision? So balancing test becomes an extremely important approach to take. And as I say, we've started drafting guidance, which I'll talk through in a minute. If we move to the next slide, we mustn't forget that individuals have rights and have a right to understand how you are dealing with their data and the basis on which you are processing it. So, just by way of reminder, here's all the things that an individual can exercise their rights on. To understand how the data is being processed, well, that should be something that you cover in your privacy notice. Right of access, or subject access request, as we might call it, rectification, erasure, restriction on processing, data portability, the right to object, and then we're going to hear, of course, from Emma about automated decision-making and profiling. But interestingly, when you go back to GDPR and legitimate interest, if the data that you are processing is genuinely processed because of a legitimate interest, where you can show that you've not overridden the rights of the individual, then the individual does not have the right of portability, does not have necessarily the right to understand profiling, etc. So we think that there may be fair and reasonable approaches that business can take to establish legitimate interest as a route to go, not for all processing activities, but for a good number. If you look at GDPR, one of the great advantages we have is specifically GDPR starts to talk about, here's some examples of where you can justify legitimate interest. Direct marketing, hurrah! At the point at which anybody that is in the direct marketing business has looked at GDPR and felt this entire thing is all about consent, fear not, because in certain circumstances you might well be able to say there is enough of a connection between us as the data controller and the data subjects to warrant further marketing where we are adding value. There's a value exchange with the data subject. The data subject has still got rights, can opt out, etc. But we don't necessarily need consent. There's also the possibility here that if it's in the reasonable expectations of a data subject, that the controller might carry out certain processing activities, then that might be a legitimate interest where, again, consent, for example, falls away. There does have to be a relevant and appropriate relationship. And again, this would be part of the LIA, or the legitimate interest assessment, to look at how you establish relevant and appropriate relationship. And some examples are given on the slide there. What about strictly necessary for fraud prevention? there are a good number of things that in business you do for fraud prevention where consent is impractical, if not illogical, to obtain. And therefore this is an ideal one for the business to say, well, here's yet another example where we can do certain things. There may be intra-group movements of staff data as part of annual appraisals or as part of merger and acquisition activity, where again it is impossible, if not impractical, to rely on consent, and we know that because regulators have already said consent is not an appropriate route to go in the employer-employee context, where you again say this is legitimate for the business to be able to exchange this type of data in anticipation of merger and acquisition activity, and provided that we can show that on balance the legitimate interest of the business has not outweighed the rights of the individual, then fair and reasonable to go ahead. There's also up there another example, network and information security, where there are things that may be done in the background that may also be done in reliance on legitimate interest. But notwithstanding that these are in GDPR, we think within the work we're doing on the data protection network that there might be a number of other logical legitimate interests that the business could rely on. For example, in terms of corporate governance and in terms of background checks on potential employees, or on the hiring of a new chief financial officer or a new chief executive, it would not be unusual to use a business intelligence company to carry out background checks. It would be illogical, if not impractical, to then obtain consent from the person you are discreetly doing a background check on for good corporate governance purposes. So there's another example where something that is regularly done in the business environment could well, provided that you've done the balancing test, give you a route to go and where consent is not trumping everything. So what you could do here, and this is very much driven in the guidance that we've been drafting and sharing with the ICO, is carry out a legitimate interests assessment. And we've developed a flowchart, we've developed a assessment form that helps the business, the data protection officer, the risk officer, to walk through, talk through this balancing test. It would give you an audit trail to be able to produce to a regulator in the event of a query or investigation as to the methodology that you applied on an accountability, transparency-based basis under GDPR to arrive at why you felt this was reliable as a lawful mechanism. So I've just extracted from the guidance notes that we put together some of the thoughts around how you use an LIA, why it is a good risk management tool, much as we will hear that privacy impact assessments are a good risk management tools, and some further examples as to where we see LI being considered. Before we move on to the next item on consent, couple of questions have come through here. Can processing for monitoring and marketing ever be a legitimate interest? I can't see why, if you can make the case that you are being transparent to the individual, that there is a logical value exchange, that the individual has got rights to opt out, and that overall the marketing opportunity is not damaging to the individual. And I agree that with no prior relationship, this is a non-starter. But where you've already engaged with an individual, it might be perfectly legitimate, provided you've been transparent in your privacy notice about the extent to which you may do things with their data, to then say, this is legitimate, but again, I would have carried out the assessment test and have the audit trail in place. We also had a request of examples where I think I've probably been through enough of those, but to the person that raised that, if they still feel that I need to address it more, do send in a further question and we'll take it as appropriate towards the end. On that, I'm going to move over to Alex to take us through when is consent really consent under GDPR.
Thank you, Robert. So the UK's Information Commissioner's Office has issued a guidance on consent under GDPR. There was a consultation running until end of March, and we are now expecting a finalized guidance. However, the draft already provides some very useful insights into the ICO's thinking. So essentially, it highlights the need for giving individuals a clear, granular choice up front and ongoing control over their consent throughout the process. It is very nicely structured, and it kind of looks more like a full guide on consent rather than just addressing the various elements of consent. For example, it also mentions what happens if it goes wrong. For example, relying on invalid consent can destroy the trust of your customers, it can harm your reputation, and it also adds you could be subject to substantial fines. So if you look at the difference between the definition of consent under that directive and GDPR, they don't really seem that different. So under that directive, it's any freely given specific and informed indication of a person's wishes. I put unambiguous in brackets because the directive also says that consent has to be unambiguously given. Now, this wording is pretty good, but as we know, it suffered from the diverse implementation across all the European member states. If you look at the GDPR definition, consent is any freely given specific, informed, and unambiguous indication of the data subject's wishes, and it's confirmed by a statement or by a clear affirmative action. So it does go a bit further than the current law. But there are clear similarities, and perhaps those similarities were the reason why the ICO, well, as well as the GDPR expressly state that you do not need to re-engineer your consents if you have obtained them in accordance with the GDPR requirements. Now, many businesses may be able to rely on their existing consents, but in probably quite a high number of cases, businesses will have relied on implied consent, and implied consent is a no-no under the GDPR. The GDPR requires active opt-in, it requires unticked boxes or some other binary choice which is given equal prominence. It requires that the individual takes deliberate action to opt-in, and this does not have to be in the form of an opt-in box. It can be also, for example, by switching technical settings away from the default settings, or to confirm it in an oral statement, and so on. But the GDPR is very clear that any pre-ticked boxes are invalid. There is no such thing as opt-out consent. Failure to opt out is not consent. You may not rely on silence, inactivity, any default setting, and you may not seek advantage of someone's inattention. So the ICO considers that the affirmative action element of the consent definition will allow for certain situations where consent is obtained and it may look like implied consent, but in fact it will be supported by a clear affirmative action. As an example here, the ICO quotes, for example, when someone drops their business card into a price draw box, or if someone submits a survey. So that will be the affirmative action necessary in order to make the consent valid. So the GDPR does not specifically ban opt-out boxes, and indeed these may be still relevant in the e-privacy world. For example, in the case of marketing to existing customers where an opt-out has to be provided. So consent has to be specific. So this means that instead of having a broad sweeping consent to all processing, it should be really granular, and people should have the freedom to agree to some but not all processing as appropriate in the circumstances. It should not be bundled with any other consent, such as consenting to terms and conditions, or consenting to a privacy policy on the website which contains all detail of all the processing carried out. In fact, under privacy notices on websites, probably the majority of the processing will be based on either a contractual relationship or the legitimate interest which Robert was talking about. So the bundling requirement, sometimes it may still be appropriate to bundle your consent with consent to other items. However, there is always the risk that such consent may be invalid, so companies should be very careful in considering this. The situations in which it may be appropriate is where there's a clear link between there's a legitimate reason for the processing that is consistent with the underlying purpose, or where there is a minimal impact on privacy, or where the organization would stop processing altogether if the individual's consent were not obtained. A further requirement is that the consent is to be freely given. So this means that individuals have to have a genuine choice. Not giving consent should not have any detrimental effect. They should be able to withdraw it as easily as they gave it. Withdrawal should be an easy one-step process and should be able to exercise that at any time. In terms of the freely given requirement, when there's imbalance between the parties, such as employer, employee, or public authority, citizen, then there is a strong risk that consent may not be freely given and would be invalid on that basis. The guidance also clarifies the concept of explicit consent, which is not defined under GDPR, but the ICO concluded that it's simply consent which is confirmed by a clear statement. So instead of just clicking submit or ticking a box, there would be an accompanying statement which the person is deemed to have accepted. So consent has to be informed, so information in plain and easy to understand language should be provided. Any vague, sweeping, or difficult to understand language that's likely to confuse people will invalidate the consent. So quite a risky affair there. You also need to consider your audience. If, for example, you aiming your business at children, you need to make sure that you explain things in the appropriate manner. One of the big changes also is that the controller's identity, as well as any other parties which will rely on consent, is fully disclosed. So we are no longer able to just define categories of third parties which will rely on the consent. We have to actually spell out their names. So in terms of consent from children, you need to implement age verification measures and make reasonable efforts to verify verify parental consent. The guidance suggests that you may be able to rely on legitimate interest in certain circumstances where you're unable to implement these mechanisms. Another important part of the new regime will be record keeping, so organizations should keep a time-stamped data file about how and when the consent was obtained, together with all information provided at the time. You should keep old versions of your privacy notices and consent language for these purposes. The guidance is quite comprehensive, and it doesn't regard consent as the only mechanism, and indeed suggests scenarios where it may not be appropriate to rely on consent, including situations where you would carry out the processing regardless of consent, or where there's an imbalance in power between the parties, or where consent is sought as a precondition to providing services, and so on. So there's plenty of other legal reasons, and organizations should be free to make use of those rather than just relying on consent.
Thank you. And I guess one of the things that I was picking up as Alex was going through there is there are examples in that consultation where you said the position of employer versus employee or public authority versus citizen means consent isn't the right solution, and that's specifically again where I think controllers will need to carry out good analysis as to the reasons that legitimize the particular way in which they're collecting data. And it's nice to see that the ICO recognizes other lawful grounds, and indeed I didn't say it earlier, but we understand that in due course the ICO will be producing their own guidance on legitimate interests, but the input that we've been giving is in fact informing and influencing them around consent versus legitimate interest, etc. In terms of assessments, we're now on to the data protection impact assessment. Brian.
Thanks, Robert. So I wanted to talk about the requirement under GDPR to conduct a data protection impact assessment, or DPIAs, recently issued by the Article 29 Working Party. So before we get into it, sometimes you can get bogged down a little bit in GDPR with definitions and terminology, but at a high level, the principle of a data protection impact assessment is probably not new to many of you. The principle is conducting some form of assessment on a new product or a new service that takes into account privacy and legal considerations. Now, in some organizations, that may be meeting with your legal team to talk about product launch, or it may be something a little more formal. The objective is to say legal compliance and, in some cases, meeting customer expectations. DPIAs under the GDPR have the exact same objective. But as with everything GDPR, it's a little more onerous, involves a little bit more paperwork, and it's a lot more serious from a regulatory perspective. And so the best place to start is the GDPR itself. Article 35 states that excuse me, where a type of processing is likely to result in high risk, the controller shall, prior to processing, carry out an assessment of the impact. So there's a number of elements there, and they're teased out in the Working Party guidance. But just to mention from the outset that the failure to comply with Article 35 is subject to a significant sanction. Now, looking on the bright side, it is the lower of the two sanctions, so it's not that 4% that we're all familiar with, but it is 10 million, or 2% of global turnover, which is obviously cold comfort. In terms of the guidelines, the Working Party talks about, and we've teased out 4 topics. When will processing likely result in high risk? That's probably the most valuable aspect of the guidance. What about processing operations in place pre-May 2018, so before GDPR comes into force? We will talk a little bit about conducting a DPIA, methodology, format, the role of the DPO and data processors, and possible publication. And then finally, we'll talk about when do you actually need to consult with the supervisory authority, having conducted your assessment and having come to the view that this activity may be high risk. So on the first point, and this is something that this guidance is really useful for, it talks about situations where processing is likely to result in high risk. Article 35 of the GDPR does provide some limited examples. It talks about systematic profiling. That's where we're talking about profiling of publicly accessible areas. GDPR talks about large-scale processing of special categories of data or data relating to criminal convictions. And they're useful, but it's really quite limited. What this guidance note does is expand on those. And so we've set those out here in a number of bullet points, and we'll just touch on each of these. Firstly, any processing that will lead to an evaluation or scoring of an individual is one that is likely to result in high risk. So in this, we could be talking about evaluating someone's performance as an employee, assessing them on an annual basis against some defined category. But it can also mean building marketing profiles based on website use. And so you can see this is actually quite a low threshold. The Working Party also talks about any processing that will result in automated decision making. So this is entirely automated. There's no human intervention when a decision is being made that will affect the user. Typical examples would be where someone applies for credit on a website. No one reviews, no individual, no human reviews the process. It is entirely automated. And those are processes that are likely to result in high risk. The second category we've touched on already, systematic monitoring or large-scale processing. Systematic monitoring, generally we're talking about CCTV monitoring of publicly accessible areas. On large-scale processing, large-scale is a term that's used in a number of places in the GDPR, and it's unfortunately not one that's defined. And the Working Party advises controllers to have regard to the volumes of data, the duration of the processing, and the geographical nature of the processing. And so it's a little bit difficult to say with certainty, but certainly any big data analytics would fall within this category of processing. An interesting one is the Working Party considers processing that involves combining two sets of data beyond individuals' reasonable expectations is also something that is high risk. And so if you look at that and think about that in practice, how might that affect what processing you wish to do? If your organization is one that offers a private messaging service, but also offers a hotel booking service, and you're looking at identifying who are your key users of both of those services, it's very likely that the combination of those data sets will, according to the Working Party, likely result in high risk. And you can see how this is something that happens on a day-to-day basis with any organization that has different offerings, different services. The next category is on sensitive data. Again, we touched on this, anything related to racial or ethnic origin, physical or mental health. Again, likely to result in high risk. But interestingly, it also includes data concerning vulnerable individuals. So that could relate to children. But the Working Party, and this has been touched on by Robert and Alex, it could also include in some cases users of public sector services. It could also include employees. And again, this is just another example of how you can see the bar for reaching that DPI threshold is quite low. Again, any innovative use of technology will likely give rise to this. So any use of fingerprinting or iris scanning with mobile devices, again, would trigger this. An interesting one, the final point there is the Working Party considers any transferring outside the EEA is something that's likely to result in high risk. So anyone operating in the UK that will be transferring or receiving data from the EEA post-Brexit this is now something that is likely to result in high risk. And this is one of the first actual official documents that talks about the consequences for an organization if it's in a jurisdiction that leaves the EEA. So having set out what categories it generally considers will result in high risk, it sets out a rather less useful rule of thumb. If you can identify 2 or more of these, the working party considers a DPIA to be mandatory. And so you can see how, whether you need to do a DPIA or not, you will still need to do this DPIA threshold test. And you can see how easily that could be reached. If you are an events organizer, you have 2 sets of data, one for a very exciting GDPR event and one for a payment services directive event. And you've gotten dietary requirements for both sets of data. If you want to merge both of those, that's now a mandatory DPA. So it's obviously quite unrealistic to think people will do that. In terms of existing processing, strictly speaking, Article 35 only applies post-May 2018. However, the Working Party strongly recommends that DPIAs be conducted prior to May 2018. We think that's probably unrealistic given all the other obligations that individuals have. However, the Working Party does say that if there is a change in risk, so if there is a category of processing that took place pre-May 2018, and that risk changes, and that could be simply as something as simple as changing your service provider for one based in the EEA to one in the US, you need to assess the new risk presented. In addition, the Working Party recommends that DPIAs be reviewed continuously and reassessed after 3 years. And so that's for everything pre-May 2018 also. In terms of conducting the DPIA, the Working Party makes clear it's the data controller's responsibility. This isn't something that can be offloaded entirely onto the DPO, although the DPO must be involved and possibly data subjects. In terms of methodology and criteria, the Working Party includes a helpful annex, which I've set out there. It's quite straightforward, and I'd urge you all to read the guidance. It's quite accessible. In terms of methodology, the Working Party makes clear there is no fixed methodology. This is entirely up to controllers. It's up to them how they fit in the DPIA process into their organizations, provided it meets those criteria. Finally, there's no requirement to publish DPIAs, although again, the Working Party does recommend that that's done. Finally, there is a clarification. There was a little bit of confusion around Article 36, which if you read it straight, it gives the impression that if having assessed your processing, there's a high risk, that will require you to consult with a supervisory authority. That is one interpretation that could be given. However, the Working Parties helpfully clarified that prior consultation is only required when the residual risks are high. So if you can implement appropriate safeguards and reduce the risk, you do not need to make a notification. Some final observations on the guidance note. Good news for controllers is that in data processing contracts, processors are required to assist controllers in the completion of data protection impact assessments. And so if you have a large outsource well-organized processor, they may be able to take quite a lot of this work off your hands, particularly in terms of categorizing what data is in place, what safeguards if it's down to security. Obviously, that's good news for processors. Just to try and put a bit of a positive spin on a lot of these, as you'll have seen, there's a DPIA threshold test. There's also a DPIA process that needs to be gone through and a review process of each of those. And you can start to see how collectively those processes really give you a good insight into exactly how an organization works, what data it has, where it shares data, the safeguards. And it's important to try and leverage all of that information and see if that can assist you with complying with other obligations. So under Article 30, an organization must keep a register of processing which sets out all that information. And so if you're an organization that doesn't have a DPIA process in place, it's important to think about this from a holistic perspective and see if you can leverage all this hard work that you're doing on a DPIA process to try and achieve some compliance with some of the other really onerous administrative paper-heavy requirements. Finally, just to mention, this is a consultation process. If there's anything in the guidance note that is really offensive or really impractical, and we know that a lot of organisations do consider particularly the continuous review of DPIAs to be quite onerous, and there is still an opportunity to make comments to the Article 21 Working Party before the 23rd of May, and hopefully they'll take those into consideration.
Thank you, Brian. Alex, Malaysia.
Yes, thank you, Robert. So just very briefly, so the Malaysian data protection law was passed in 2010 and came into effect in 2013. It was at the time described as European-style privacy law, and many local businesses considered it really onerous. However, commentators noted that it is a step in the right direction. So it has all the usual stuff about data controllers. It has principles. There's a notification requirement. Apparently 20,000 data controllers have registered. So there's an office of the Personal Data Protection Commissioner. But it seems that progress is being made quite slowly. So the Commissioner issued a security standard in 2016 relating to, obviously, information security as far as personal data is concerned. And this was criticized as being very specific. For example, it obliged organizations to keep customer data only for 7 days after the end of the commercial transaction, or to revoke an employee's access within 30 days after they left the organization. Also, controllers have to keep a weekly user log in order to monitor their access to data. So quite specific requirements. It also encouraged the use of CCTV in terms of physical security. Now, the next step, we have heard that the Malaysian Commissioner is consulting on data transfers. So currently, data transfers may be made if they are made to a country which is listed on a list which is published in the official Gazette. To date, there is no such list in the Gazette. Alternative mechanisms are consent, contract, vital interest, public interest, and of course legal proceedings and legal advice. And two peculiar ones are where the transfer is made in order to prevent adverse action against the data subject, where consent cannot be obtained but would have been obtained and been asked for. It's quite a strange one. And then another one which says that the controller has taken all reasonable precautions and exercised all due diligence to ensure that the receiving country will not process data in contravention with the Malaysian data protection law. So now the consultation will actually mean that a list of adequate countries will be published. And currently the draft order includes EEA countries. It includes UK separately, presumably because of Brexit. It includes countries which are considered adequate by the EU Commission, and also some neighbors of Malaysia, such as Australia, Japan, Korea, China, Hong Kong, Taiwan, Singapore, the Philippines, and Dubai. I would just mention the Philippines are very interesting because they seem to have adopted a GDPR-style privacy law. But I think that, again, the implementation is very slow, and although it's a step in the right direction, it may take years before it's properly implemented. So just in conclusion, the list of countries for Malaysia is a good thing, and it kind of validates our usual practice of adopting model clauses for transfers to Malaysia and out of Malaysia.
Good, thank you. And last but not least, Emma, and profiling.
Thank you. So on the 6th of April, the ICO and the Information Commissioner's Office published a discussion paper on profiling and automated decision making in the GDPR. And the deadline for responses was the 28th of April. The ICO is going to publish a summary, but one of the main reasons for the paper was because it's going to submit the responses to help inform the UK's contribution to the Article 29 Working Party guidelines and on profiling and automated decision making. And these are due to be published later this year. This has actually been prioritised for release, so it will come out by the end of 2017. So just a few points to note. It's not formal guidance from the ICO. They've got a large caveat at the beginning saying it only represents their initial thoughts. But caveats aside, we thought it'd be helpful to discuss it because it gives us an early indication of the ICO's views on profiling. So the first slide we're coming to is just setting out the risks and benefits as the ICO sees it of profiling. I mean, as most people will understand what profiling is, we'll come to the legal definition under the GDPR in a moment, but at a general level, it enables aspects of an individual's personality, behaviour, interests or habits to be determined, analysed and even predicted. Customer profiles, user profiles, social profiles, anything, and it's often used in marketing. So as you can see, the ICO has got quite a few risks that it identifies. And although it sets out the benefits, one of the main things that the ICO wants to stress in its paper is that profiling is becoming an issue of real concern. And that's part of the reason why it actually lists out the significant effects that can arise, which include underrepresentation of certain sectors of society, use of non-sensitive personal data to deduce sensitive personal data, unjustifiable deprivation of goods and services, and loss of data accuracy. So what does the GDPR actually say about profiling? I won't go through this slide in detail, but you can see that the definition is set out at the top, and it means any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects, in particular to analyse or predict certain aspects. And just going through one of the main things to note is that Article 22 sets out that individuals have the right not to be subject to decisions based solely on automated decision making, which produce legal or significant effects, unless this is necessary for a contract, for example, or is authorised by EU or national law. And although Article 22 deals specifically with automated decision making, it also comes up in terms of notice requirements and individual rights, and also privacy impact assessments. So the topics I want to mention briefly about the ICO's interpretation, the first thing, just a baseline point, is that the GDPR defines profiling as set out on the slide, and it has this automated element. Now the ICO, in its feedback, request for feedback, actually states it has the analysis element of it, but there isn't this predictive element. And it's an early indication that the ICO's preference could be for potentially a wider interpretation of what profiling and automated decision-making entails than the text of the GDPR actually suggests. And one of the things that the ICO has asked for feedback on is whether stakeholders agree with this approach, or whether they think that there should be a predictive element or some degree of inference for the profiling to be considered, for the processing to be considered profiling. So you'll wait and see what the results of that is. And the second thing that I wanted to highlight is that the Article 22 right, which enables individuals not to be subject to decisions based solely on automated decision making, which produce legal or significant effects. The ICO, the word solely, obviously, it indicates it will be only on this basis. However, the ICO thinks that it's intended to cover automated decision making where a human exercises no real influence on the outcome, rather being solely based on automated decision. So no real influence is obviously different to solely. And again, it indicates the ICO is going potentially wider than the text of the GDPR suggests. One of the important things about the feedback paper is that it the ICO offers an interpretation on legal effect and significant effects. The GDPR actually doesn't define these, and so this is potentially quite helpful. And as you'll see, a legal effect is probably quite self-explanatory. A significant effect, however, is something that's more than trivial, with potentially unfavourable outcomes. Again, this is relatively wide, and we'll wait to see what the outcome is of the responses. The ICO has actually suggested it could be useful to establish an external recognised standard to measure significant effects that are free from bias of the controller or the data subject. And in terms of the safeguards organisations must put in place, the key aim is to make sure that if profiling takes place, that it's fair and non-discriminatory and does not have an unjustified impact on individuals. And there are different measures the ICO suggests: algorithmic auditing, accountability certifications, codes of conduct, ethical review boards. So, and finally, as Brian's obviously already mentioned, many profiling activities are likely to need a data protection impact assessment, and obviously the Article 29 Working Parties Guidance will be the main authority on this, and it's potentially just worth noting the ICO gives credit scoring, insurance premium setting, location tracking, loyalty programs, and behavioural advertising as examples of activities they think are very likely to require a DPIA, and crucially, which I suppose will sort of depend on how far solely is interpreted, but they were indicating here that if the decision is partially based on automated processing, then it could still require a DPIA. And just finally to note, obviously the feedback paper covers a wide range of topics, and I haven't got time to go into all of them now. There were just two things I wanted to mention before finishing, and that is that in relation to transparency, the ICO states that information that should be provided to individuals about how profiling might affect them can be general. It doesn't have to be information about a specific decision. So this is potentially helpful for controllers rather than having to go into a huge amount of detail. And in terms of explaining the logic behind the decision, it doesn't have to be a technical description, but it should clarify the categories of personal data used, the source of the data, and why the data is considered relevant. You also need to make sure that you're clear about the individual's right to object. It can't be hidden in the T's and C's. And just to draw the threads together of one of the themes running throughout the webinar today, in terms of having a legal basis to process based on profiling or automated decision making, consent can operate as one basis, but the ICO states this may be difficult, therefore other forms of legal basis are going to come into play. For instance, the forms of a contract or for the legitimate interests of the controller or a third party. However, the ICO stresses that the controller must be able to demonstrate that the profiling is necessary to achieve that purpose rather than simply useful.
Thank you. And we've actually got a question for you, Emma. So what about performance management software that's used at work, and the example we've been given here is that in the background, the speed of keystrokes or the lack of keystrokes might indicate that somebody is not working. Do you think that that is caught by automated decision making?
Probably would need further details, but from an initial assessment, given the scope that the ICO seems to be putting on the definitions of automated decision making, and potentially, especially looking at impacts for an employee at a company, and they're using that information to assess you, then it probably would be quite a strong case that it could well do.
Yeah, I was just thinking it'd be like, you know, having CCTV and saying, well, he's got his eyes closed. Well, I close my eyes when I'm thinking. I'm genuinely working, honestly I am. We also had a good number of questions, and I'm not sure I'm going to be able to go through all of them, but we had a good number of questions that came in the employment context as well around legitimate interest. And I think it's quite clear when I look at what GDPR says, when I also look which I can't share with you right now, the feedback we had from the Information Commission's team to the guidance we put together, that you really do need to be sitting down as the controller and, in anticipation of GDPR, looking at the types of data that you process, the reasons you're processing it, and what justifies what you're about to do. You might form the view that you can't go wrong if you've got consent. Somebody who has expressly said, I agree to A, B, C, D, there can be no argument about that, and there may be on a risk basis that that's the route that you go with the business, is as much as possible, let's get people to say yes. Let's recognize they can always change their mind and say no. But there will be some other situations, like monitoring in the workplace, like background checks, like the data that you collect for anti-money laundering purposes, or for fraud, or on take-on of employees, or job applicants, where consent is not an appropriate mechanism, where it wouldn't even be valid consent because of the imbalance between employer and employee. And then you have to say, well, what does justify it? It could be legitimate interest, in answer to one of the questions we've had, but it could equally be contractual necessity, that I need to gather that data about you because of the health insurance that we offer to our employees. It's not something where consent justifies it. It may be that it's part of the contractual relationship, and it may be that there's vital interests that also come into this. So a takeaway, I think, actually from what Brian was talking about, and what we've been hearing about in terms of the automated decision making, is that GDPR is driving controllers, and in some cases processors, to have to think more carefully and produce an audit trail of how they arrived at a choice of the lawful grounds for processing, how they arrived at a decision that what they were doing was fair and reasonable, how they make available the rights of a data subject, etc. So there is much more transparency and accountability, keywords that we hear in GDPR, and I think the more that you can show, and I use this expression a lot, that we were moving in the right direction, and there is the process we went through that produced that end decision, the better you will be. So all of these things are good risk management tools. We have gone beyond the end of the hour, so I apologize for the overrun, but thank you for all the questions that came in, and sorry if I wasn't able to deal with every one of them, but we will be doing another webinar in June. I've yet to fix a date. For those of you who've been on this webinar, it was recorded, and the slides will be available next week. So from me, on your behalf, thanks to Alex and to Emma and to Brian and to Jana on the technology, and we will be with you on another occasion. Thanks. Bye.